employee engagement is important when it comes to things like performance and disputes, right? I mean, if an employee is not engaged, they don't perform. If they don't perform, they then get taken for hearing and so on and so forth. In some cases, they might feel it's unfair because of things, right? And that's where the CCMA comes in. But my point here being that, again, the employee seems to be sidelined in matters that affect them directly, right? What makes you happy? I'll provide it for you. Rather than I'll give you the power and the agency to provide it for yourself by having you become more free in your assessment of value to say, no, this is what I deserve. This is what I should get. Right?
Remember, we have rights derived from the Constitution.
Yeah.
However, the same Constitution limits those rights. There's a limitation clause in the Constitution. If I get employed, for example, those code of conduct, those collective agreement, that contract, it's a kind of, you have a policy that is a risk management tool to say, we want you to be safe and we want to make sure that we deal with and mitigate all the risks within the workplace, and we can do that via a policy. It means the workplace does not become a free-for-all. We must know their limitations, that not barriers, limitations that are acceptable, justified, and reasonable. Now, though if an employer, for example, creates benefits, those benefits may even extend to your home. A medical aid, for example, you have dependents that includes. You've got a housing allowance that is extended to your dependents. You have, for example, you've got policies that also extend loans or study, whatever you want to study. You have those benefits of accessing. Your children can be taken to school. They can be trained. We have that situation where employers, within their means, they are able to give that assistance away from the workplace, because if it was they taking care of you and you alone, and you have those extended responsibilities, and the employer ignore that, it may impact on your ability to perform, because you may be stressed out. So we have those employers, those benefits, those packages that people do enjoy. Including with the economic and inequality, it's exactly what you have said. We have a challenge.
Yeah, we do.
But I wonder if we'll reach equilibrium where all of us end the same position, same path. I wonder.
I also wonder if that's what we really want.
We can better our situation. Your equal pay for work of equal value is one of those ways that can be used to try and bring equity. But it becomes a mirage. The closer you get, the further it goes.
Right. So now moving on to NEDLAC's Code of Good Practice, right?
Yeah.
How would you differentiate an employee from, let me put it this way. From my reading of the Code of Good Practice, the main differentiation that I found was the strongest was the legal liability that an independent contractor faces in case of poor performance or lack thereof, or lack of performance. Whereas an employee is not found to be legally liable, but the employer being legally liable for the employee's lack of performance. Am I understanding that correctly?
Okay. Now, Section 213 defines what is an employee. And Section 200A of the LRA talks about a presumption as to who is an employee.
Okay.
The definition of the employee in Section 213 excludes an independent contractor. It excludes. However, Section 200A put a presumption as to when we have to put the test. That means being an independent contractor will be a rebuttable presumption, meaning everybody is regarded to to be an employee until the contrary is proved.
Okay.
Now, we remove this veil and then applying the test. As we apply the test to you, are regarded as an independent contractor in terms of the label.
Yes.
However, if we apply the test, we may find that no, irrespective of what this contract says, this person in essence, in the true sense of the word, is an employee and therefore is protected. Or we may find that indeed you are an independent contractor. So there is that definition in terms of 203 and there is that presumption in terms of 208. For example, if I go to the Act, it talks about it says until the contrary is proved. For the purpose of in any employment law and Section 98A of the Insolvency Act, a person who works for or renders service to any other person is presumed,
To be
regardless of the form of the to be an employee, and if any of the following factors
Yes.
applied. So we can give you a contract that say you are an independent contractor, there you are. It means we can, if it's brought to us, you can say irrespective of the form of this contract, my view is that I'm an employee. CCMA determine this matter, and we can conclude that no, you are an employee, or we can confirm that you are independent. So that's the line between the two.
What are some of the factors? Not all of them, because I did read the document. There's a lot of them,
okay.
right? My reading of the document, I found that the differences seem to be arbitrary, right? I mean, things like Let me ask you this specific question. How would you explain the restriction of an employee to employ another person? So if I work for you as an employee, right, and you hire me to do something, and then you're gonna pay me 50 Rand for that. I get someone to help me, I'm gonna give him half of my 50 Rand, right? It seems to me, and correct me if I'm wrong, that the employee is, and I would even go as far as to say, legally restricted from doing that.
Okay.
Right? Can you explain the thinking or the sort of, the context of that?
If you are an employee, we entered into that employment relationship. The obligation, we have corresponding obligation. I want you to render your services personally. I want you to be at work. I'm paying for you. If you want to engage somebody else to do the work with somebody I don't have any control, I don't have powers to assess and evaluate and to perform appraise, it creates that conflict because I want you to be here. I want you to render your services. You must be at my disposal. If you cannot, then you must give reasons why you are absent. Or you are the same as you cannot hold another job whilst I may need you and you are engaged somewhere else. So it is that conflict that may arise in the interim. If you are independent, I don't want you personally to come here. You can send anybody because you are an independent contractor. We have contracted to deliver. Maybe you are an IT person. I want you to install X, Y, Z. So we entered into, you can bring your own people because I'm interested on the outcome, the end result, whether you have delivered on the project, is it satisfactory within timelines, how you deliver with whom, as long as I'm happy at the end. So that is a line that needs to be drawn.
What is the difference between you selecting a specific company over another company, right? Because if you're saying an employee is someone that you contract personally, what's the difference between contracting an employee, an individual, personally, and contracting an individual juristic person? Isn't that still a personal? Isn't
okay.
Yeah.
Let's say you are Tumi. Tumi, with the same. Exactly. But you have registered Tumi Enterprise or Tumi Consultancy, which means Dumi Consultants, your PTY Ltd, is a juristic person can be sued, and they can sue in their name. And therefore, if we enter, we contract this juristic person to deliver XYZ. And if this juristic person does not deliver XYZ, we have recourse. We can, sue, or they can sue us. We can take them to court. But a natural person, that's you, in your personal capacity, we employ you to be here, and we'll apply our policy to you. You are part of the organization. We'll register you with the UIF if there is a need for that. We'll put you in, enjoy our benefits. We'll offer you a payslip at the end of the day, and we want you to be personally here. We can also discipline you. It means you are the person, that we are dealing with. But with a juristic person, to me, blah, blah, blah. We don't necessarily deal with Tumi as a natural person in his or her personal capacity. We are dealing with Tumi as a company. That we can hold responsible or liable for such. Same applies with an employer. An employer can be held liable by an employee under the EEA Section 60. If there are issues of discrimination and harassment, the employee can hold the employer vicariously liable. So it will depend.
So you mentioned a number of factors there. We give you a pay slip. Right. You said you become a part of the company. We apply our policy to you. Right. So would you say that all those characteristics can be applied to an independent contractor? Can an independent contractor be made to be part of the organization?
Yes.
Like catering, I've seen catering services in government departments, for example.
Yes.
Even in private companies, where the catering services is actually an independent contractor, but they operate there.
Within, because the employer, because of the nature of the business, they do provide those tools.
Yes.
I've seen even in your field, you find I am an independent journalist, but I operate from the studio, SAB, then they provide me with whatever. So the nature and the reasons for doing that also can be because of the nature of our work, we need to do the following and assist and support this person, however they remain independent.
And therefore, even though they remain independent, while still being situated on your grounds, on your premises, and therefore becoming part of your organizational culture, it means that your policies will apply to them as well.
The control, that is the control test. Are you controlling the hours of work? Yes, you can say, no, we open at 8, we close at 4. They cannot be here before or after, even if they are delivering a project.
And the contract would stipulate that as well.
We justify in that. That's why we say it's a presumption.
So what is the difference between a contract between an independent contractor and a contract? And I don't mean the legal difference, because there is a legal difference, I understand. Just like there is a legal difference between an employee and an independent contractor. I'm just not seeing that difference practically.
Okay. Here at home, we have commissioners who are full-time. I'm an employee of the CCMA. I'm employed full-time employee. We have another colleague of mine who is regarded as an independent part-time commissioner. Even if they are required to conduct themselves ethically and to behave accordingly, they are not barred from accepting other jobs outside the CCMA or continue with their practices and charging whatever they charge.
As long as they are here during the hours.
If we need them here, they must be here.
Okay.
If they fail us, that contract may be terminated or they may be due for a hearing. But they are not barred as to what do you do outside. You have a meeting like this, you charge for the 3 hours. And how much do you charge? You pay taxes. Those are your private businesses because of the nature of the contract. But it doesn't mean you can come here when you want as you please. If you sit in a process the code of conduct for commissioners will also apply to you because of the nature of the environment or the nature of the relationship. So those are some of the things that will be put to the test. And based on the facts of each case, then we can be able to say, now we successfully managed to pass that corporate veil, or no, indeed, there are justifiable reasons why the employer and the employee has to, coach their contract in a specific way. So that gives room for the employer. And also if the employee, you work for a company, you rock up yesterday, they tell you, you know what, the truck that you drive, it's yours from now onward. However, you're still earning the same salary. So they want to circumvent the law. They say if you terminate, you can't go to the... When you come here, then we realize, no, that's just a veil. Let's remove the veil.
Disguised employment.
Exactly, absolutely. It's a disguised form of a contractual arrangement.
Yeah.
It